Next order of business will be the roll call of House members. If you're present, please indicate your presence by voting aye. Chair excuses Representative Dvorak. Chair's going to log in those members that are escorting the judiciary.
That's hot, not high. That's as high as they get. With a skirt on, no less. Connie, did you get that stack of mail to my house?
Representative Smith, would you like to
I got a stack of Senator Puffs.
tally the roll? Roll call shows 99 members present. Chair declares a quorum. I'd like to welcome all of you. Sorry you caught the business we normally take care of before our guests are with us today, but we have a number of honored guests that are joining us today, and it's my pleasure and obligation to introduce those folks. In the first row of the balcony, we have Amy McDonald, the wife of the Chief Justice. And their daughter, Maddie Shepard, is also with us. We also have with us today Jan Aikman Dixon, the wife of Justice Brent Dixon. Dr. Denise Rucker, the wife of Justice Robert Rucker. It is our sincere pleasure to have with us today the former First Lady of the state of Indiana, Judy O'Bannon. Our Attorney General, Greg Zeller. Greg. Our Auditor of State, Tim Berry. Mr. Berry. Dr. Tony Bennett, the Superintendent of Public Instruction. You better bring a note from home. He's tardy. In the second row, we have former Supreme Court justices with us. It's a sincere honor to have with us today Justice Ted Boehm, Justice Myra Selby, Justice Roger DeBruler, and also Bob and Helena Cross are with us. You two are listed as former Supreme Court justices. I've not read either of your opinions, but we'll be checking on those very soon. We also have in the gallery the president of the Indiana State Bar Association, Eric Chickadance. The president-elect of the Indiana State Bar Association, Dan Vinovich. The president of the Indianapolis Bar Association, Michael Hebenstreet. And the president-elect of the Indianapolis Bar Association, Scott Chin. We also have members of the Indiana Judicial Nominating Commission, but they're not listed on my program, so would you all please rise so that we can recognize you together. One moment. We also have with us leaders of the House and Senate, of course. In the Senate, we have the President Pro Tem, David Long, Senator Long. The Majority Floor Leader, Connie Lawson. The Majority Caucus Chair, Jim Merritt. The Minority Floor Leader, Vi Simpson. The Assistant Minority Floor Leader, Jim Arnold. And the Minority Caucus Chair, Tim Lannon. He also needs a tardy slip. In the House, we have the Majority Floor Leader, Bill Friend. The Majority Caucus Chair, Kathy Richardson. There must be a coup going on that I'm unaware of at the moment. They're both off the floor. The Minority Leader, Representative Pat Bauer. The Minority Floor Leader, Linda Lawson. And the Minority Caucus Chair, Vanessa Summers. It's my high honor and privilege to turn the gavel over to Lieutenant Governor of the state of Indiana, Lieutenant Governor Becky Skillman.
Members of the Joint Assembly, pursuant to Section 3 of Article 7 of the Constitution of the State of Indiana, this joint session of the General Assembly is now convened for the purpose of hearing a message from the Chief Justice of the State of Indiana. It's my privilege to present to you the distinguished Chief Justice, the Honorable Randall T. Shepard.
Thank you all so very much. Thank you for your welcome. The reports that the Constitution directs the governor and the Chief Justice to give are known as the state of the state and the state of the judiciary. But very little in public or private life is actually static. These annual snapshots always reflect a journey from where we used to be towards something we hope will be new and better. And I'm always mindful that the Constitution calls on me to report on the state of the whole judiciary, not just the appellate courts, but all 400 of Indiana's courts and the 640 men and women who sit there, in short, a report on the larger enterprise that's moving from yesterday to tomorrow. The yesterday of Indiana's courts lasted largely unchanged for decades. As in many other states, our courts were a collection of silos that rarely connected. There were few agreed-upon ways of conducting business, of assigning disputes that people brought, or managing those disputes to a speedy end. For much of our history, rules and practices varied so much from one courtroom to the next that people might well have thought they were crossing a state line when all they did was go to the county next door. That began to change about a generation ago. And over time, Indiana's courts have become less like a collection of Lone Rangers and more like a group of colleagues with a common purpose. The legislature created unified courts in the state's urban areas, and it began to support collaboration between judges through the Judicial Conference of Indiana, the Judicial Center, and the Division of State Court Administration. And that movement was evident even in 2011, when the legislature created 3 more unified courts in Henry and Clark and Madison counties at the request of judges and county officials who'd reached the conclusion that they could be more effective by working together more closely. And at your prompting, the Judicial Conference adopted rules to consolidate the probation departments in those few remaining places that continue to operate as though criminal justice could succeed in a series of silos. You could call this growing commitment to joint effort court reform or dollar tax efficiency, and it's both of those, but it makes a difference in the lives of real people. You can see that in fields like family and children and domestic violence. A generation ago, courts heard those disputes about the same way we hear disputes on property ownership or breach of contract. The techniques had simply not grown along with the size of the problems. And that has changed dramatically. Indiana's ability to care for abused and neglected children, for example, is light years ahead of where it was just a decade ago. Governor Daniels launched an agency that focuses now solely on children, whose caseworkers have enough training and time to do the job right. And the legislature has taken the expense of protecting those children off the backs of property taxpayers. As for the judicial branch, when children did find themselves in court in days gone by, no one really spoke for them because the parents were so often focused on their own conflicts. Today, Indiana courts have people who speak just for the interests of the child, sometimes lawyers, but more often volunteer court-appointed special advocates, CASAs for short. The administration and the legislature gave the judiciary the resources to recruit and place and support an army of volunteers who speak only for children. Indiana now has more local CASA programs than any state but Texas. In 2011, we trained the largest number of new volunteer advocates ever, 1,010 in a single year, and as a result of that, the number of children awaiting assignment of a CASA is half what it was a year ago today. For particularly acrimonious divorces involving children, we now offer family mediation, something that didn't exist even 2 decades ago. Judge Tom Feltz of Fort Wayne, who's here today, first launched this initiative, and you authorized us to use it statewide, and we now employ it in 33 counties. In cases involving the worst threats, we have more tools than ever for combating domestic violence. In 2002, you made important changes to the statutes on domestic violence protective orders. But when a court issued an order, it existed only on paper, making it even harder for law enforcement to enforce the orders. Not anymore. Thanks to the Judicial Technology and Automation Committee led by Justice Sullivan, when a judge issues an order now, we send it immediately and electronically to every local law enforcement agency. And JTAC has also enabled local victims advocates, people like women's shelters, to direct access to the protective order registry, and victim advocates do that in 61 counties. This time last year, I told you we were on the way to being able to send texts or email messages, that's the way people learn things today, to send immediate messages to the victims at the moment when the protective order is served on the abuser, a particularly dangerous moment in relationships. And JTAC has completed that work, and last year we sent electronic notices to 9,300 victims. These are improvements that literally save lives. That same seriousness of purpose is the story in criminal justice. When I was a trial judge, judges mostly had two choices in sentencing: prison and probation. And during the intervening 25 years, governors and legislators and prosecutors and defense lawyers and judges have wrestled continually with the twin problems of growing prison populations and recidivism. But state and local ingenuity have produced a different world. We now have 49 certified drug courts, highly professionalized probation departments with the time and the tools to monitor felons who are there by the tens of thousands at any given moment, 4 times as many felons under supervision as there are in the Department of Correction. 56 court and drug court and alcohol programs, the first veterans courts in Indiana as a result of legislation you gave us last year, delinquency projects run jointly with school corporations and the social work community, and the new risk assessment tool to help identify the most effective sanction for individual offenders. Last year, we used that to evaluate 134,000 offenders using 21st century techniques. There is deep interest at the local level in finding more effective approaches. In May, the Department of Correction and the Judiciary invited people in the criminal justice community to a statewide summit on evidence-based sentencing, and 774 people showed up. Prosecutors and judges, defense lawyers, community corrections and probation officers, school corporation staff. It was clear to me that the spirit of reform and effectiveness in criminal justice is alive and well at the local level. And this spirit is no place better illustrated by a project on evidence-based strategies that's underway in Grant County, led by Judge Mark Spitzer, who's here today, and by the elected prosecutor James Luttrell, that the U.S. Department of Justice has decided it will use as a national guide for the best way to sentence people. Among the most heartwarming aspects of stories written these last few weeks has been commentary on the fact that Indiana's courts are not a barrier to economic development, and you could all name states where people shy away from investment because of litigation climate. One way the legal system can be a barrier has to do with sheer complexity. On a simple matter like how you get evidence into evidence in court. For 175 years, Indiana used a system based on the ancient common law. You looked it up in appellate court opinions, and if you were very lucky, you found one that gave you the answer. If you weren't quite that lucky, you found 2, and they gave you 2 different answers. How to establish whether a document is genuine, whether it's hearsay or not. And people confronted with those problems had to research thousands of pages for guidance. We've replaced those millions of words with the Indiana Rules of Evidence, 24 pages. covering everything from hearsay to when you need an original and when a copy is all right. Now, there are still debates about evidence admissibility at trial, but at least everybody's singing off the same page. Lawyers and judges can know what rule applies and spend their energy deciding how it ought to apply in this particular situation. And citizens who find themselves in court without a lawyer can use this relatively simple roadmap to navigate for themselves. Now, calling a reform like that modernization passes over what it does to hold down the cost of litigation and improve citizen access. The same is true of the jury rules. A recent study put Indiana fourth in the country for the fairness of juries. And we know, because we've received national awards, that those juries are the most representative, most inclusive juries in America. And the same can be said with the plain English jury instructions, which give jurors a fighting chance to rise up out of the legalese. The other barrier is potential. It's partially organizational, it's partially mental framework. Do people in courts understand that how we perform affects a state's economic climate? And I suggest that the work that three branches have done on mortgage foreclosure proves up our bona fides on that point. Led by Lieutenant Governor Skillman, with energetic participation from General Zeller, Indiana has been revising statutes and developing new court practices to give homeowners a better chance to rewrite their mortgages and stay in their homes if that's possible. The judiciary has been working to focus all these techniques in the place where it matters, the courthouse. And we've now deployed these new package of practices in 20 counties that represent 2/3 of all the state's foreclosures, including the 10 counties hardest hit. We're still adding places where we're at work doing this same thing, but that's not the news. The news is that after a full year of experience with the practices that all three branches made happen, it's now clear that these processes multiply the chance that a homeowner might achieve a successful workout 6 times over where we used to be. And that really matters to the people in question. Now, that's important for homeowners. It's how we usually talk about it, but not for homeowners alone. After all, a functioning real estate market is part of what a healthy economy needs. The people who do lending in real estate understand that in a heartbeat, and one of the case managers that you helped us place recently wrote in praise of the many mortgage company lawyers who, she said, view this as a win-win opportunity. It is for homeowners, for lenders, for neighborhoods, for local taxation purposes. It is a part of making Indiana's economy move. And that leads me to tell you something about changes in the legal profession that ought to be a source of pride. Indiana became a state where lawyers have to do continuing legal education because lawyers asked that that be done. They thought it would be good for them and for clients. It was a proposal by the Indiana State Bar Association. Their initial proposal included only lawyers and left out judges. And the judges said, we won't do that. We won't ask lawyers to do something we're not willing to require of ourselves. And by the way, Indiana lawyers don't just do the minimum. Last year, Indiana lawyers spent 70,000 hours in the courtroom above and beyond what the rules require. But last year, something happened that was sort of that same spirit. As a result of the Judicial Conference's strategic planning, judges proposed that judges should have a higher requirement than practicing lawyers, and now we do. What else is better about Indiana's legal profession? Well, we've improved the bar examination, improved admissions by adopting 3 new national tests, including one on ethics and one on problem solving, emphasizing 2 crucial points. We created the country's first joint program for impaired lawyers and judges, created the first statewide Lawyer Leadership Academy, a project of the State Bar in which Justice David is playing a leading role, and created, with your help, the Indiana Conference on Legal Education Opportunity. It is a very old-fashioned form of affirmative action, the sort that once brought together Jesse Jackson and Richard Nixon, if you can imagine. And as a result of the last 13 or 14 years of working at what you gave us the resources to do, we have managed to double the number of minority lawyers in Indiana, and that says a lot that's good about Indiana. And Cleo has started to produce judges. Now, number 3. And she's here today. You appointed number 2, and he got reelected. And she is here today. Kenya Jones is now judge in the Hammond City Court. Won't you stand up so everybody can see where you are? Well, I don't see it. Delayed by highway investment, no doubt. Now, most of what I've said applies to the whole judiciary, but I want to say a few words about the appellate courts. I could talk numbers, but I'd rather talk to you about quality. And there aren't many ways to measure that, but one of the ways is, are the opinions written in Indiana ever cited by anybody else because they represent good thinking? And people do actually count that. And there was a time when Indiana stood very close to the top as a place where other courts, lawyers, scholars, other judges looked to for answers to the legal problems of the day. In 1912, first formal study, in 1912, there was a study examining how state courts cited each other, how often they did that, and Indiana was 5th in the country after only New York and Massachusetts, Illinois, and California. A similar exercise in 1920 showed Indiana ranked 8th. A study in 1936 concluded that Indiana ranked 15th. You can probably see where this is going. By 1975, a study of reputation of state Supreme Courts placed Indiana 25th. Only 2 other states had fallen farther than we have. But that's not the way it is today. 3 examples. Chief Judge Robb recently wrote an opinion for the Court of Appeals on environmental liability. It has already been cited by courts in Texas and in Massachusetts. It's been included in a national handbook on insurance law, explored by a law journal in Ohio, and cited by the American Law Institute, very uptown. Two other snapshots. A national expert in sentencing reform, somebody who actually knows, said to me recently that Justice Dixon's opinion on the use of risk assessment in sentencing was the best thing anywhere in the United States, and he knew what he was talking about. And then I was at a conference not long after that where the Chief Justice of Nevada said to me, "Boy, I'm sure we're glad we had that opinion from Frank Sullivan on gaming law." I said, "What are you talking about? Nevada is reading Indiana for gaming law." And he said it was the best work. It was the only court in the country that had successfully wrestled this particular legal problem to the ground. And that's what's going on. And it is, of course, a source of professional pride. It is part of the reason, I think, why more people vote in retention elections than ever before. But pride is not the reason why it's important. The reason why it's important has something to do with the value in the public sector of what George Will recently called reasoned judgment. Whether the disputes people bring are thoughtfully and honestly decided according to fact and law is crucial to a free society. And that's why it's important to do a really good job. Now, these are but some of the most evident trends about where we used to be and where we're going. It's not humility but simple fact for me to say that the circle of people on the bench and in the bar who have been lending ingenuity and leadership to this is very broad indeed. We're very well served. I'm going to give you some examples. Very well served by people like Lily Judson, our state court administrator, who's just finished holding the highest office in court administration in America as a leader of the National Center for State Courts, and Mike Whitty, now of our Disciplinary Commission, who just stepped down as the leader of all the nation's judges in the American Bar Association. And I want to tell you that every member of the senior staff in the Court of Appeals and in the Supreme Court has held positions of national leadership inside the judicial and legal world. And we're very lucky about that. very lucky about that. Judges, too, Justice Sullivan breathed new life into the cause of bringing more minority law students into clerkships, and he's now leading the national effort of all of the American bar on ethics and professionalism. Judge Wayne Trockman, who is here from Evansville, a member of my former court, has done such groundbreaking work in drug courts that the National Association of Drug Court Professionals recently came to Indiana to give to him its Transformation Award. That's what Judge Trockman has been. And Judge John Surbeck of Fort Wayne, fairly called one of the inventors of reentry courts, is literally in international demand for his expertise. Not just judges. I was in Washington recently when Jan Dixon was rightly recognized by the National Center for State Courts as having done more for the families of judges than anyone anywhere. And Justice Robert Rucker, who chairs the Judicial Council of the National Bar Association and whose career has been such a model to others, that the Lake County Commissioners recently renamed the facility in East Chicago the Robert Rucker Courthouse. that was the right thing to do. These extraordinary people and so many others engaged in making the system of justice work better today than it did yesterday. Aiming higher, a friend of mine said. And their collective commitment is the reason we can be confident about tomorrow. Here are some examples from the last 12 months. After winning national awards for innovation from organizations like the Council of State Governments, JTAC, led by Mary Depry, is on the verge of deploying our new 21st century case management system in 40% of the state's cases. On the subject of public safety, 44 new law enforcement agencies began using JTAC's electronic citation system. No more writing of tickets for them, bringing the total to more than 250 from the state police to the St. Joe County Sheriff's Department. They'll be tomorrow in the Austin Police Department and at Anderson University. Last year, more than 1.3 million tickets were processed using JTAC technology. And yeah, I know that. Yeah. Half of them are warnings. You should know that half of them are warnings. Our program on civics, Courts in the Classroom, won its 10th award, this time from the National Council on Public History, for success in helping teachers and students and the general public understand their courts and understand their government. The Public Defender Commission of Indiana added yet another large county, Delaware, to the network of upgraded local public defender services, and the national experts on indigent defense have been writing stories about Indiana. Judge Diane Schneider of Lake County and others have launched groundbreaking work on guardianship for those seniors who have no family to look after their affairs. And Judge Schneider likewise spoke on our behalf in urging you to adopt the brand new Uniform Guardianship Act. I want you to know that you have embraced the gold standard. Representative Foley is one of the people who was its sponsor, Representatives McMillan and Delaney, Senator Zachas, Head and Broden, Senator Simpson and others. I want you to know you have embraced the gold standard for how to address the affairs of seniors in the immediate future, and your timing is impeccable, just in time for the tidal wave of retiring baby boomers. It's exactly right. To be engaged with so many splendid people in so many worthwhile causes has for me been a career better than one could ever imagine. To deliver this final report standing in this chamber where so many valuable measures in support of a fairer society have found success is uplifting. And to do it between Mitch Daniels and Becky Skillman is poignant. We have known each other for a very long time. I'm very grateful for what Governor Daniels said last evening. I am more grateful for the fact that he has been an inspiration on so many occasions. And I say to both of them, your friendship has enriched my life. And if a guy was going to end up in the public mind remembered at the back end of a hyphen, how could you do better than being after the hyphen with Joe Kernan? That's a pretty good arrangement. That's not bad. Could there be a better cause, a more worthwhile way to spend and be spent in life than working towards greater justice? The scores, if not hundreds of times, when members of the General Assembly have been willing partners in developing measures for a more just society has been a great gift. Those many moments and the demonstrated achievements of the many people in the bench and bar are the reasons why I say Indiana will have an even better system of justice tomorrow than it will today. I've carried my own role in all of this with the love of Amy McDonald. She and my daughter, Maddie, are very grateful for the countless generosities and acts of kindness you have all shown us. That graciousness and plain observable fact will allow me to leave the stage with full confidence that we will succeed in building Indiana as a safe and prosperous and decent place. And that is the state of your judiciary.
This joint assembly is adjourned.
The House will stand in recess for about 10 minutes. I missed only one introduction, ladies and gentlemen. Happens to be to my immediate right, the governor of the state of Indiana. House will stand in recess for the fall of gavel in 10 minutes.